Good morning, all. This case management conference is in the matter of CFI 081-2024 before His Excellency Justice Roger Stewart, KC, and is being held by way of video conference, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is a litigant in person, represented by Mr. Stephen Docherty. The defendant is represented by Khalid Abdullah Al-Tamimi Advocates and Legal Consultants, and lead counsel is Mr. Ryan Turner. Thank you, Your Honour.
Thank you very much. First of all, I apologise again for the fact that I'm a disembodied voice. Secondly, I apologise for the fact that the timing of this hearing was changed yesterday at short notice as a result of an unavoidable change to something that I was doing. Right, I've read the papers and I'm grateful to the parties for the substantial degree of accord which they have reached. It seems to me that the issues that need to be determined are the overall progress of the matter to trial, which in turn depends upon the timetable for document production, to a smaller extent witness statements, what the appropriate orders are in relation to expert evidence, and what the trial length should be. I propose to run through those matters, but before I do so, are there any other matters which the parties would like to have addressed at this hearing?
From claimant's perspective, no, Your Honour, I'd listed those four matters to address you on, and I think those are the drivers of the differences between us this morning.
Thank you very much, Mr. Turner.
Agreed.
Right, can we just deal with document production first? Now, you're both agreed that you can produce the documents you want to rely on by the 4th of October. Can I just understand, and the defendant has identified categories of document which it has indicated in due course it wants to seek from the claimant, and has identified, I think, that it's got about 500 documents of its own to produce. What's the extent of the claimant's likely document production, please, Mr. Docherty?
Yes, Your Honour, it's not a lot. It's not a huge volume. I think we identified it as no more than sort of 1 to 2 lever arch files on standard production.
And in terms of what you're likely to be seeking from the defendant, do you have a view as to what you're likely to be seeking or not?
Yes, apologies, Your Honour. I thought that a case management information sheet had been filed, which had identified at least some of those, but it may not find its way into the bundle. But the documents which we presently envisage seeking largely relate to the case on quantum and getting a proper understanding of that. I'm sure that as the case goes on, there will probably be some requests around some of the factual issues in dispute, and a lot of the more fact-heavy issues arise from the counterclaim. So that will feature as well. But at the moment, as I'm sure we'll come on to in due course this morning, the predominant blind spot in this case from the claimant's perspective is understanding what the case on quantum is and what the supporting evidence is for that.
Well, I'm going to be asking some questions about that, particularly in relation to expert evidence. I mean, it seems to me, therefore, looking at the, sorry, Mr. Turner, am I right in thinking that you've got something like 500 documents that you're going to produce on standard disclosure?
Yes, it's in that order. And we would anticipate, in relation to the initial production, that would significantly cut down any likely request to produce from the claimant, we would hope, as we'll be relying on the sorts of documents to substantiate losses that it seems Mr. Doherty has mentioned just before, and also set out in the claimant's case management information sheet. So from my client's perspective, any requests to produce are likely to be fairly limited as made against my client, and the requests to produce that are listed in the case management information sheet, again, are defined categories on particular events and particular dates, and that don't in my submission extend to any great any great complex matters of state, frankly, and they should be able to dealt with in a reasonably short time frame and in a proportionate manner.
All right. Now, as I understand it, the timetable for production of documents, it's agreed that you should give standard disclosure on the 4th of April of 2025. That's right, isn't it?
Yes.
And then the timetable, I think, is then agreed, save in relation to the period for turnaround of the disputed requests to produce and production of requests to produce. Have I understood that correctly?
Yes, so I think we're agreed up to the point of filing the objections, and it's the process that follows thereafter where there's still a considerable difference in the amount of time allotted.
Well, I think the difference is this, right, is between your date of I think it's the 18th of July, isn't it?
Yes.
And Mr. Turner's date, which is the 13th of June, have I got that right?
Correct.
And I think the difference between those two comes down to giving the court an extra 2 weeks to decide, and giving the parties an extra 2 weeks to produce following dispute. Is that right?
I think there are a couple of drivers behind it. I'm happy to run you through where we get to the 18th of July, because I realise on the face of the order it's not entirely obvious.
Well, perhaps you could just give me the dates, because it would be just helpful just to identify that, Mr. Lockley.
Yeah, so built into that is an assumption that once the objections have been received by each party, within 2 weeks of that, it's assumed that they will file their application for a document production order. If one assumes that that's plus 2 weeks, one then runs through the Part 23 procedure, assuming that these are normal applications rather than heavy applications. So that's
sorry, just the standard disclosure of the 4th of April. Can you just give me the dates on which you want? So the 4th of April is standard disclosure.
Yes, 4th of April standard disclosure. Request to produce 2nd of May. Oh, sorry, request to produce 18th of April.
Yeah.
And then objections to or compliance with requests that are agreed 2nd of May.
Yeah, and we're agreed up to that. Then go on. Yeah.
So the 18th of July date from there allows the parties 2 weeks to consider whether they will make, and if they so choose to prepare a document production order application.
So document production order application will be the 16th of May on your timetable. Yeah.
Yes. And from that point, one then follows, assuming, as I say, that these are normal applications, the Part 23 procedure. So there would be 2 weeks thereafter to provide evidence and answer, and then 1 week for evidence and reply, which brings you further 3 weeks forward.
Yeah, which is the 7th of June.
Yeah. In the period thereafter, what the parties need to do is to liaise and list a hearing, prepare a bundle, prepare skeletons. And so I've allowed, I suppose, a long stop day on that of 3 weeks to get a hearing on. So that would bring you to, and then from that point, there's an element, of course, which is out of the parties' hands, which is the time taken for a decision. What I've suggested is,
and then you've got the time for production on the 18th of July.
Yes. Yeah.
Okay.
So that's allowed an extra 3 weeks. I realise that that's tight potentially from the court's perspective, and obviously it depends what's going on at the time. But what I had hoped fits alongside that is the period that has been provided for in the claimant's draft directions on witness statements, which potentially allows a little more float, so that if there is a longer period between the hearing and getting a reasoned decision out, there would be capacity.
We'll come on to that in a second. All right. Now, well, I understand how you get to the 18th of July. Is there anything more you want to say about that? I mean, you've identified some points in your skeleton argument. Is there anything more you want to say about that?
No, I think we've, from the claimant's perspective, tried to put together something which is reasonable and as short as is feasible. But I think our main point is that this is feasible and realistic as a timetable.
Okay. Mr. Turner, what do you say?
Thank you. The overarching submission, which you'll probably hear me make a few times today, is that ultimately this is not an unduly technically complex matter in respect of the underlying dispute as to whether or not there has been and was a breach of contract by KITOPI in the performance of its services. Yep. And in those circumstances, any likely disclosure and that's to be requested by my client is likely to be limited in scope and not unduly complicated. And certainly it's something that my client's already laid out in its case management information sheet, that there are certain categories of documents it intends to request.
Just on that, at the moment, it seems to me that the scope of disclosure is relatively limited on both sides, although the focus is going to be rather different. Your focus, I think, is going to be rather more on inquiring about what you said factually went wrong in relation to these meal packs and so forth. Mr. Doherty, who I assume has rather greater knowledge of the factual position so far as the meal packs, etc., is rather more focusing on what you say about quantum, from what I understand it. So there's a rather different focus, but in either case, it doesn't seem to me to be enormously complex. All right, yes, go on.
No, I thank you. And that is the central submission on disclosure, is that a timetable which allows what I submit is a significant delay at the very early stages of these directions is to be avoided if at all possible. This is a dispute which arose as far back as December 2023. And delaying yet further on matters of disclosure. And
can you just give me give me your respective dates? So I've just got them down.
Yes, yes, of course. So the draft order, as included in the CMC bundle, provides, as I say, the agreed dates up to the 2nd of May, which is when requests to produce go in.
Yeah.
The next and then really the next long stop date is the requirement to produce documents that arose from a document production statement, which would be the 13th of June. The reason for that date is pursuant to the case plan, which gets generated by the court indicating its desire to move cases expeditiously. The case plan suggests that the procedure to be adopted by the court in matters of this nature, i.e. not heavy technical, overly contested and multi-million or billion dollar dirham disputes, you may have time for evidence in reply, evidence in response to applications, and further other details. But in a matter of this nature, it's my submission that the request to produce and the objections to that request to produce are all the court needs to be furnished with to make a decision on whether or not disclosure is to be ordered, and that's the methodology proposed by the court in its initial case plan, and when matters get through their pleading stages. And
so just give me the dates that you would be contending for, or which are set out in the case plan for those.
Yes. So you take the 2nd of May as when any objections to the request to produce are made.
Yeah.
An application for a document production order to be made within 7 days thereafter, or 14 days as the court requires. That would either be the 9th or the 16th of May.
Yeah.
The standard order from the case plan gives a 7-day period for the court to turn around, which would be the 23rd. But I've allowed in the order.
Now, let me just float two things for you. I mean, it seems to me that in this case, at that point, you will have the request to produce and the objections. if one imagines a procedure akin to arbitration, you'd also have an opportunity for a response, which you wouldn't otherwise have. And it seems to me that what you could build into this is a request to produce by, say, the 9th of May, with any additional brief reasons as to why the documents sought should be provided, which would effectively be a reply. And it seems to me that you could then say by the 16th of May, the opposing party was to provide any short reasons in response. And I think you could have all of those set out in what one would call in arbitration a stern schedule or something of that nature.
Yes.
And you could then, I think, provide that the court would endeavour to produce responses to that within 2 weeks in writing.
So taking those dates, you have objections to request to produce 2nd of May, 9th of May, any application.
Actually thinking about it, I think one would give until the 16th of May for the applications.
Yep.
And I think one would give until the 23rd of May for any further response for that. And then I think one would be looking at the court to produce a response by, say, the 7th of June, and then documents to be produced by the parties in response to that within, it seems to me, 3 weeks, which would give you to the 28th of June, which would mean that neither of you are entirely successful, but you get the documents out pursuant to a written procedure by effectively the end of June. Now, Mr. Turner, I'm only floating it, and I'm going to ask Mr. Doherty for some response, but what would you say to that as a procedure in this case?
Yes, that procedure is in line with the initial discussions as between the parties. That my client did propose that procedure whereby there were replies to objections, but we attempted this streamline approach merely to seek agreement initially, or to offer to the court. So that timeline would be agreed by my client readily.
Okay. Now, Mr. Doherty, what that does effectively is that it means that you haven't got the full procedure for applications and so forth. On the other hand, what you would have is a procedure which is pretty well equivalent to that for document reduction in arbitrations, and indeed in many arbitrations where very substantially more is at stake than in this case. What do you say about that?
Yes, I mean, one can certainly see the logic for trimming the use of the Part 23 procedure, not least because I think often, although that is the standard procedure that the court follows, it often ends up looking a lot like the Redfern type schedules that you get anyway. So one could readily see that you can build in a time saving that way. The only hesitation I have is that it's often in the best intentions of parties to say that issues are going to be dealt with cooperatively and that they might be relatively minor. In the event that that doesn't happen, it may well be that the parties decide that actually there probably needs to be a short hearing to deal with some of the more disputed issues. And it would be whether, for example, one might build into that timetable a period of, say, 3 days after applications have made to either request or not from the court a hearing which could be listed within, say, 7 days or 2 weeks, whatever it happens to be thereafter. Or the parties can indicate in writing to the court either their agreement that the procedure continue in writing, or to make submissions on why they think an oral hearing is necessary for the court to determine.
Right. Okay.
My only hesitation, as I say, is that in the event that one of the parties decides that actually there is sufficient distance between the parties that a hearing of less than 2 hours might be required, that there wouldn't then be the time in the timetable to allot that.
All right. Thank you. Anything else you want to say, Mr. Doherty?
No.
Right. On this issue, it seems to me that it is appropriate to adopt a procedure which effectively involves the parties seeking to reach agreement, but if not, to produce what would be the equivalent of stern schedules. I say that for, I think, three reasons. One is that submissions as to document production are rarely helped by extensive oral matters. Secondly, that this is a case in which the volume of document production is relatively limited. Thirdly, it's a matter which I would be determining, and I've got, I think, a reasonable grasp of what the issues are likely to be in relation to document production. And therefore, it seems to me that what is appropriate in this case is a slightly modified form of the directions which are proposed by the defendant. The parties are agreed down to the time of objections on the 2nd of May. Thereafter, the directions I make are as follows, that if there are any requests to produce, they should be produced in writing by the 16th of May with brief reasons in schedular form. The schedule should have the original request to produce, the objections, and a brief reply, and that should be done by the 16th of May. The other party, if it wishes to add anything to the schedule, should produce any further brief reasons of objections to the request to produce by the 23rd of May. The court will then seek to determine those matters in writing by the 6th, I think it is, yes, the 6th of June, and the parties would then produce the documents which they've been ordered to produce by the 27th of June. What that therefore means is the document production phase of this hearing will be ended by the 27th of June, and that's the order that I make in relation to documents. Now, in relation to witness statements, the defendants, I think, are calling 5 witnesses. And from what I understand, those witnesses will be largely going to questions of the loss and damage which it has suffered and possibly some repudiation. Have I understood that correctly as far as the defendant is concerned, Mr. Turner?
Yes, there will be, the intention is up to 3 witnesses on the loss and damage and up to 2 on breach.
Okay. And what about your witnesses, Mr. Lockney?
Yes, so at the moment it's envisaged that it will be 2 to 3. So on the assumptions 2 will be 1 dealing with commercial aspects of the dispute and then 1 dealing with the operational factual side, but there would be potentially up to 2 witnesses on the factual operational aspects.
Sorry, I missed that. So you're going to have two or 3, or are you saying it could be either 2 or 3?
Either 2 or 3.
Right. So we could have up to 6 witnesses. Is that right? 6 factual witnesses.
It could be up to, if it's 5 from the claimant and 3 from the.
Sorry.
Defendant could be up to
8. It's going mad. Yeah. Okay. Now, so far as the timetable for this is concerned, both parties, I think, agree that a period of 10 weeks is appropriate from the end of the document production process. Is that right?
No. The view of the defendant is that the appropriate order is for a much shorter period for witness statements, and that's on the basis that, and as the court has indicated, this is not a matter where document production is likely to be overly complicated or reveal some great matter that is not otherwise well known to the parties. As I say, a dispute that's been ongoing for almost 18 months now, and regarding works, and that work in my submission on the witness statements could commence now.
Well, just pausing there. There will have to be overlap with documents from your side's point of view. One would expect that your factual witnesses would be, possibly certainly ones in relation to quantum, would be explaining the documents which were produced either pursuant to the request to produce or in response to, either voluntarily by way of standard disclosure or in response to requests to produce, and saying how they've suffered loss. That's, as I understand it. Now, on breach, they shouldn't probably be looking at the other side's documents, but one imagines they're going to be looking at that. Anyway, yeah, I mean, that's right so far as you're sorry.
So the sum submission is that a period of a month from the end of the document production process is a suitable period of time in circumstances where. So
your bid would be for the 25th of July, which is 4 weeks from the end of the document production process.
Correct, on the basis that the parties should be well advanced in witness statement preparation, or at least the substance, by the date of their initial disclosure in a couple of weeks' time, and anything that's arising from the document production process after request to produce would be limited and could be dealt with within a month of that final production being ordered.
Right. Okay. Now, Mr. Dockley, I think you are saying that it should be 10 weeks. And therefore, I think what that would mean is that on the basis of the document production by the 27th of June, you would be getting, I think, to the you'd be getting, I think, to the 5th of September on 10 weeks. Is that right? No, sorry, that's not right. Yes, it is. I think you'd be bidding to the 5th of September. Is that right?
Yes, I've just counted that forward, and I think that's right.
And presumably, you'd also be making the point, apart from anything else, that
well, I suppose quite
a few people going on holiday in August and July, I think is the way I'd put the pattern.
Yes, I mean, there's invariably the difficulties one encounters over summer. There's also and again, it comes back to what's a reasonable and feasible time period. Of course, it's in pretty much everyone's interest to keep things as tight as possible. The DIFC case progression flow charts set as the default for this step 10 weeks. One could assume that you would be able to expedite that if you had a fact-like case where you had only one witness say a fact on each side. You could see grounds for shortening that. Where we're dealing with up to 8 witnesses, it's difficult to see what justification there would be from the standard direction that would normally be issued by the court of 10 weeks.
Yeah. Okay. Mr. Turner, anything more you want to say?
Nothing further to what I've already said.
Okay, and I'm going to order the 5th of September for witness statements. On the one hand, it seems to me that there is force in what Mr. Turner says, which is that quite a lot of the witness statements which give legitimate evidence on either side can start to be done now. On the other hand, it does seem to me that there are a total of 8 witnesses, that the period, I think Mr. Doherty's period of 4 weeks is too short. In any event, that means a witness statement preparation after witness evidence is going to take place during the summer. Things don't come to a complete stop here, but it does seem to me that in overall terms, an appropriate period is the 5th of September for witness statements. So that's the order that I'm going to make in relation to witness statements. Now, expert evidence. Mr. Turner, I think the burden is rather upon you, and your skeleton is refreshingly light in relation to what this expert evidence is actually going to be.
Yes.
Now, you've identified someone. First of all, what profession is the person that you've identified?
They're an accounting expert. Right. So measures of quantum. The reason for their expertise, if I might, I don't know if it's helpful for me to turn up the pleadings, or certainly the last pleading which the defendant produced, which sets out some headline points.
Yeah.
You may have picked up from the papers and the various orders made by the courts and listed in the case memorandum. This case has a rather unfortunate tortured history in relation to the issuing and closing of various cases and files. The pleading appears at page 51 of the bundle.
Yeah, let me just have a look at let me just look at that. This is the reply, or the
So yeah, this is the final shot across the bows between the parties. So this is the reply to defence to counterclaim.
MONS' reply to defence to counterclaim.
Yes.
Yeah, and which page?
So begins at 51. The page where lightly dealt with is the issue of loss and damage, at least the headline points. Sorry. Page reference. It is at page 72.
Hang on, let me just get that.
And from paragraph 73 onwards is where, as I say, as you said previously, lightly is perhaps the correct.
Right. So sorry, paragraph which? Oh yes, paragraph 73. Okay, let me just read. Let me just read that. Okay, I read that. I mean, I'm rather inclined to think at the moment, Mr. Turner, that you ought to be volunteering some form of schedule and identifying what your loss is and what you're contending for, with at least the basis upon which you arrive at it. What do you say to that?
My client would be readily willing to provide a schedule of loss included within the timetable if that would assist the party in determination, in at least setting the agenda as to what experts are to review it, and I'm sure we can consider, or I can consider, whilst Mr. Doherty's speaking, where that could sit within the timetable. But
well, I mean, what I'm wondering about is this: you're going to be producing your witness statements by the 5th of September, and you've identified that at least a significant amount of your witness statements are going to be dealing with loss and damage. And it seems to me that logically by that stage, you'll have had all the documents, you'll have considered them, you'll have your factual evidence, you've got your expert up and running, either by the 5th of September or very shortly thereafter, and by which I'd mean probably something like the 12th of September, i.e. a week. Yes. It seems to me that you ought to provide a schedule which identifies what loss and damage you're claiming and the basis of it. Now, I'm not envisaging an enormous document, but I am envisaging something which has got the number of dirhams and the basis of them, so that we can see what you say about them and the basis on which it's put forward. What do you say to that?
In part, that schedule or quantification of loss is addressed through the parties' proposed directions on sequential experts.
Well, so, I mean, I have seen the sequential expert point. What I'm thinking about at the moment is this. I think I am minded to order sequential experts, something subject to whatever it is that Mr. Doherty says. But I also think that one ought to just have a bit of an agenda for that beforehand, because from Mr. Doherty's point of view, I think rather than simply being given an expert report, he ought to be given a list of points so that he can start thinking what sort of expert he wants, etc., rather earlier than the present position. So I mean that's presently where I'm thinking. The alternative, I think, is that you produce an expert report plus a schedule at the same time. But again, at the moment, I can't see why you can't be doing most of that work in order to produce it pretty shortly after the witness statements on the 5th of September, because I don't think at the moment that you're going to get anything from Mr. Doherty's report, which doesn't need to be taken into account, and you're going to know what your own witness is going to say.
Yes. Your Honour, the 12th of September seems a suitable date for a particularised schedule of loss, which then, as you say, the expert, the defendant's appointed expert can speak to. It doesn't induce any real meaningful delay into the timetable. So, yes, at the 12th of September for an articulated schedule of loss.
Okay. Now, as I've already indicated, I also think that probably it is appropriate for there to be a sequential exchange, because he can't come up and running. So I think the first question is, how long would you need for your report after either on or after the 12th of September?
It could be very shortly after. in my submission. So we would be willing to agree to the sorry, I'm just checking on the order as we're sort of working our way through it. We have initial witness evidence 5th September. We've then allowed for 2 weeks for reply evidence.
I mean, do you really need replies here? I mean,
that was merely addressing that point. In my submission, I don't think there is need for it.
Okay. When I next give Mr. Doherty the chance to speak, I'll ask to him about replies. But at the moment, I certainly can't see why expert evidence should be tied to reply evidence. So it seems to me on the expert evidence point, let's just proceed on that basis for the moment.
We would say from the date when from the date then of witness evidence on the 5th of September, the expert report could be produced by the 19th. Sorry, I'm liaising with by instructing solicitor by email. If the schedule loss was on the 12th, we could produce on the 19th September.
So schedule loss 19th to 12th and expert report 19th. Very good. Now, that then leaves, which I'll hear Mr. Doherty on in a minute, his expert report. And I also would want there to be an opportunity for the experts to meet and produce a joint statement. Now, in this case, given the way it is, I think the joint statement would probably come after his report, and sometimes it would be appropriate beforehand. At the moment, I'd take some persuading that one needs reply reports. So I think in this case, what one would be looking for is a date for him to produce his reply report, and then a date for the expert's joint statement.
Yes, so we have 19th for the defendant's expert report. As the defendant puts it in their draft order, we were willing to say that 6 weeks would be an appropriate period of time for determination.
And 6 weeks would be the 17th of October, 31st of October, and the joint statement 14th November, something like that.
Yes, 2 weeks thereafter for a joint statement. That allows for time for some meetings over a fortnight period, and then the agreement of a joint statement by the 14th.
Okay, is that a set of directions with which you would be content, Mr. Turner?
Yes.
Right, Mr. Doherty.
Yes, I suppose 2 points. One on sort of principle or scope of expert evidence, and then 2 on the timetabling issues. One thing that, from the claimant's perspective, is still unclear is what particular issues this expert is going to speak to. So Mr. Turner went to the pleadings, but if you're on wanted to turn them up again, it's page 21 is the original pleading.
Your point is that the pleadings don't help much.
Well, but they don't help much, but they also seem to point towards quantum issues which are actually more akin to factual issues. So, for example, a 10-day loss of revenue, one doesn't necessarily see why one would need quantum expert evidence to deal with that, because it's presumably simply a matter of looking at what the daily revenue is and multiplying that by 10. Again, issuance of refunds and issuance of vouchers appears to be a factual question of what refunds were issued and what vouchers were issued. It seems that the potential area is the still relatively vague assertion of entitlement to damages for tarnished reputation. I mean, that appears to be a loss of a chance pleading, but we don't know what specific contracts that's said to relate to.
It may raise some yes. Well, I see force in your point. I mean, one possibility would be for just, I mean, you probably got it anyway, but just to express the point that the court doesn't now give permission for expert evidence, but that if the claimant wishes to provide expert evidence, then it produce it in accordance with the timetable I've just been discussing with Mr. Turner, and that you object to that if so advised within, well, probably 2 weeks of the service of the expert report on you on the 19th of September, and I'll then determine the issue. Now, I'd probably determine that issue on the papers, but I mean, I might need to have an oral hearing in relation to it. It seems to me, however, that the timetable of 6 weeks probably allows you to, well, I think what I'd probably do is still make the orders for 6 weeks and so forth. But when I then thought about when the trial should be, one would allow a little bit of slippage in case your objection led to some delay in relation to determining that. I think that's the way I'd look to it. So I think the long and short of it is I see force in your point that the expert issues haven't been fully identified. I'm not prepared, I think, to force Mr. Turner to identify precisely what he puts forward now, etc., because I think that's just going to delay matters. But I'll give you liberty to object. I mean, I'm not encouraging you to object. But on the other hand, I see force in your point that I suspect there is probably legitimate scope for some expert evidence here. And it seems to me that the claimant has got, the defendant has got sensible counsel involved, and one would hope that that would produce a sensible report. But I'll give you liberty to apply to object to the report and proceed in that way.
Yes.
Sorry,
if I might,
let me hear from Mr. Doherty first, and then I'll hear from you, Mr. Turner.
Thank you.
Just the other point surrounding that is in relation to a schedule, and I suppose one of the difficulties is, particularly when it comes to things like document production and witness evidence, is that at the moment, what still the claimant doesn't know is, what specific opportunities are said to have been lost. And it may well be that those aren't, quantifiable to the dirham at the moment, but one wonders whether, for example, it might be possible to produce a provisional schedule of loss, which can then be updated at around the time the expert reports are due, so that there is an earlier understanding of precisely what the issues are going to be, so that those can be thought about and dealt with as much as possible when it comes to disclosure in particular, but then to the extent necessary in witness evidence. Because it seems the concern that I have is that an expert report can't stand in the place of adequate pleading of what your case is on quantum.
No, well, I see that. All right, well, I understand that, but I'll ask Mr. Turner to respond to that. Any other points you want to say about the timing of this?
The other is the difference between us on timing of reports. I think we've suggested 8 weeks. The reason for that should be relatively easy to understand, which is, at least as currently envisaged, we're somewhat going in blind to the exercise. And so that extra 2 weeks is likely to be necessary for us to understand what the case on quantum is, if that's the first time that we're really getting to grips with it and dealing with it. In relation to reply reports, again, given that the claimant's position is that we're not entirely clear on the issues that expert evidence is required, as I don't think we have any particular objection to keeping the process tighter and dispensing.
Well, I mean, you're going to have you're bluntly going to have the advantage in that respect, that you're going to see his report first.
Well, yes, and of course the experts, assuming they're both sensible, will sit down and deal with it in their joint statement anyway, so we'll know what the points of difference happen to be. Really, the timing issues from our perspective are contingent on us actually having knowledge for the first time of what the case is and being able to respond to it.
Yep. Okay. Mr. Turner, what do you say in response to that?
In relation to matters of principle as to why expert evidence is necessary, and indeed why the court should be granting permission, and in my submission not leaving open the door to the claimant to raise some last minute objection. In my submission, the purpose of the expert evidence is to ensure that the trial of this matter is not unduly bogged down in questions as to whether or not there has been appropriate allocation of losses, whether there's been an appropriate quantification of various points, and that the expert can stand as an independent process appointed by both parties, who can agree at the very least on a figures basis whether the various heads of loss, i.e. those past losses that my learned friends referred to in relation to the breaches, the COP28 contract, if we'll call it that, and the various vouchers and refunds. Quantum experts all the time consider invoices, losses, and various costs.
Mr. Turner, I mean, as I say, I suspect there is probably scope for expert evidence here. That said, with the greatest respect, your pleading, or it may not be your pleading, but the defendant's pleading couldn't be said to be the most illuminating document that one has ever seen in terms of how the matter is put forward. It's you that's wanting to get this on quite quickly. The alternative would be for me to order you to set out now a pleading of your loss, etc. But I suspect that would take rather longer. As I say, I'm the assigned judge for this. I've got a reasonable amount of time in the autumn, and I can determine these issues pretty quickly. But anyway, yeah, okay. Well,
I understand the point. I merely just wish to point out that one of the issues that my client has faced through these proceedings is the fairly obstructive approach by the.
Well, we
have concern. Just have concerns on the issue of leaving open this liberty to apply, and if the court's persuaded now that permission is appropriate, that it should be recorded in order.
I'm not persuaded, in all honesty. What I'm saying is that my experience of cases like this suggests that there probably is legitimate scope for expert evidence, which is rather different from saying that you've set out and identified what those issues are.
Okay, thank you.
Right, well, look, what I'm going to order is this. I'm going to order a schedule of loss by the defendant by the 12th of September. I'm going to order the production of an expert report by the 19th of September. I'm going to give the claimant liberty to object to that by 2 weeks after that, which is the 26th, 3rd of October. I should say on that, I mean, I've given literature. The basis for any objection would be that the report doesn't properly deal with matters of expert evidence. I would encourage the claimant only to make such an objection if it really thinks that things are going to be gained for it. I think that's all I'd say in relation to that. If not, I'm going to split the baby in terms of the period of response. I'm going to say that the claimant should provide a responsive report by the 7th of November, which gives it 7 weeks, and that the expert should then meet in order to seek to agree matters agreed and not agreed by 2 weeks after that, which is the 21st of November. If there is an objection, I will look at it and I'll give directions in relation to it, although I may well determine such objection on the papers, as I think it's likely that I will be I am the assigned judge and I'm likely to be the trial judge. So that's probably what I'll do in relation to any objection, but I'll consider the nature of the objection and when it's made. That therefore means that we have got the evidence competed on the current timetable by the 21st of November. Now, my present view is we should have a PTR. I think that PTR should take place before Christmas. And I think probably that the matter ought to be listed for probably after probably something like the 21st of January. I haven't seen what the 21st of January is, but that sort of period of time, that gives a little bit, not too much, but it gives a little bit of slippage. It also ends up, as it happens, about halfway between the periods which are contemplated, which is the end of November by the claimants and the end of March by the, the other way around, but it's about halfway between the parties' positions in relation to when this matter will be ready for trial. And that then leaves the question of the trial estimate. The two contentions are 5 days with, 5 days, and the other one is 3 days with one in reserve. I think the appropriate listing here, having heard anything, is 4 days, which that will be reviewed at the PTR. So all of that therefore means that we're going to be looking for a PTR before Christmas and a listing after January, as I have identified. Do either of you want to say anything in relation to that?
I suppose the only thing is whether I think that the parties had expressed that they were content for the hearing to proceed as a virtual hearing, but it might be that that's a decision that can be taken at the PTR or not, or one that needs to be taken now. I know that
it probably does. Well, I think this. Do either of you positively contend that you want to have an in-person hearing? I think the present position is that a 4-day hearing, as it were, doesn't entitle you to an in-person hearing, and it also seems to me that the sums involved in this case, whilst being significant, are not enormous. And experience suggests. But if either of you positively contends that this ought to be an in-person hearing, I'll make inquiries as to whether or not that would be possible. I certainly think in terms of flexibility of listing, having it fully remote is likely to lead to greater flexibility.
Yes, I think my understanding is the parties had indicated a preference for it to be a virtual hearing anyway. Sorry, I might have misstated what was in the case management information sheet for the defendant, but that's what I thought had been the case.
Well, that's what I understood. So unless either of you are positively contending for something different, this will be a virtual hearing. As I say, it'll be 4 days subject to review. I mean, I should say that if it's a virtual hearing, it's likely that if, for example, the parties were to say, well, actually, looking at it, we think it's going to be 5 days, it'll be probably perfectly possible to accommodate that. But
yes,
that's by the by. Mr. Turner,
virtual, from the defendant's perspective, the virtual is the preference anyway. I'll probably be travelling to the region just for the time zones, if nothing else. But a virtual hearing is perfectly suitable.
All right. Well, it's going to be a virtual hearing. It'll be 4 days. That'll be subject to review at the PTR. The listing will be done in the normal way, both for the PTR. I think the PTR should have a listing of 2 hours. And as I say, I think it should take place. Well, if the evidence should be finished by the 21st of November, I think we probably want the PTR at some time after, or probably actually sometime after the 12th of December, but before Christmas, I think.
Just on the listing of the PTR, sorry, just as a query, it seems to me that there'd be no reason for needing to list it any later than the last date for evidence. So it could be listed any time from the 24th of November. It seems to me.
I mean, the only reason suggested that it is possible there will be some slight slippage in these times. I'm not encouraging that, but if one leaves it a little bit later than that, it means that the judge, i.e. me, has got the opportunity to look at all of the evidence, which I think is helpful.
Very well. So the first open date from. She said the first open date from the 8th, which would be.
I think I said later, but the 8th is right. But with the aim of doing that before Christmas. Sorry, I think Mr. Doherty has been wanting to say something for some time.
It's quite. I was just simply going to ask, in returning a revised version of this order, would it assist if Mr. Turner and I have a discussion and
that would be
give a list of dates for both sets of trial?
I've been taking a fastidious written note, so I will endeavour that. Hopefully,
there are 2 stages. One, it would be of assistance, I think, if you were just to agree the dates between yourselves and give it to the registry. In terms of listing with the registry, what I'd suggest is that you then deal with the registry as soon as possible and get the dates listed as soon as possible. I mean, for a virtual PTR, I don't think it will be any difficulty because, as is apparent, if necessary, I will sit at some ungodly hour of the morning before the rest of the day gets on, and assume I'm in England. So there we are.
Thank you, Judge. Just one question, Judge. Just on following the PTR, it's the defendant's position that the trial could be listed anytime 4 weeks after the PTR. That would be from the 5th of January. I wanted to check on court sitting. Does the court sit from the 5th?
It does, but I for reasons to do with my diary, I think we'll list it from the 12th, actually.
From the 12th. Oh, very well.
All right. Anything else from either of you?
Yeah, I think that's everything.
Thank you.
Yeah,
and I'm sorry.
That's it. Yep.
I'm sorry that the listing was changed, and I'm sorry that I've been appearing as a disembodied voice. But very good. Good to see you, and thank you to everyone else for their assistance in relation to this.
Thank you, Judge.
Thank you.